It's The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
All right, and welcome to The Law Show. Today we are focusing on estate law and estate planning, and the reason we chose the Beatles is because we're talking about how a will is your final goodbye sort of letter to the world. So even though you're saying goodbye, you're saying hello to the people that remain and what's going to happen to your estate. John Lakes and John White join me. The two Johns are going to be very easy for me today because you're both named John. From LakesWhyteLLP in North Vancouver, a law firm experienced in the entire estate planning and estate litigation category. Today we're going to be talking about the basic rules of what constitutes a will. Gentlemen, welcome to the show. First of all, both Johns, I don't know who's to jump in here first. Who wants to talk about your background? Has it always been estate law for you guys?
Well, I've been practicing law for over 30 years. I'm a solicitor, and I do not just wills and estates, but I deal a lot with real estate and small business. So generally my clientele are the middle class people, and the idea is that we can deal with most of their legal issues. And
so it's life planning kind of, right?
Life planning and buying and selling houses and doing wills are an important part of their overall plans. So
I know in my instance, whenever I've done a major purchase, especially buying our home, the first question was, do you have a will, right? And is that what you often ask?
I do, or else not only do you have a will, but when was the last time your will was done, too? Because there's an awful lot of people have wills, but they're 30 years old and they're totally out of date. They're still naming guardians for their kids who are now in their 30s or 40s. So.
Okay, and John, what's your background?
Well, my background is mixed. Again, it has never been all estate litigation, but I do
So that's the difference here. One's a solicitor, one's a litigator?
That's right.
Yeah, okay, so explain the difference.
That's the big difference between our practices. Mine is all litigation. It includes estate litigation, but other areas of litigation as well, commercial litigation, employment law, personal injury law as well, but once again focused on what the people in our community require in terms of the resolution of their disputes. We just find that a lot of those disputes tend to revolve around estates.
Mm-hmm. And you know what's interesting? If you polled 10 families and you said, what is the number one item of strife that's happened in your family? People not speaking to each other, people are estranged from the family. It's usually come down to a will or somebody feels jilted when someone's passed away. Is that what you find?
Unfortunately, yes. We've seen far too many instances of that. It I guess is something that just isn't going to change. People get very upset about these sorts of disputes.
I'd say if anything, it's escalating because now that an average house is worth $1 million, there's a lot more monies to fight over. People are living longer. There's more occurrences of second marriages, so you have blended families as well. So if you have somebody die who is broke or owes more money than their assets, no one's going to fight over their estate. But now that primarily because of the growth of real estate value, the average person's estate has increased considerably, and it's usually a dispute over money. There's not much dispute over things because a lot of people will find that they may have spent a life accumulating things such as Royal Dalton, China, and things like that. First of all, there's not much of a market to sell it, and quite often a lot of things that people may have, the next generation do not want either because they already have enough things or they've got a small apartment or whatever. But
and we live in an era where if you want things, you go and buy things because credit is easily available, right?
Well, also there's a change of value too, because I'll have older clients they have their Royal Dalton in particular that they really prize or antique or big pieces of antique furniture where either there's not the demand for it by the next generation, or second of all, they don't have the room for it either. So
it's not in style, right?
No.
So on today's show, we are going to go through the basics because I think it's very important. And just, talking to you gentlemen before we started here, I have so many questions I could ask you and so many different instances where you have, as you mentioned, blended marriages, somebody who's maybe part of your will that doesn't live in the same province, the changes in the rules here in British Columbia. So today we're going to talk about the basic rules of what constitutes a will, executors and trustees, their roles and the issues, execution of the will, and help me with this, testamentary documents, is that right?
Testamentary documents.
Testamentary documents, okay. So basically, what is the will? We used hello, you say goodbye, I say hello with the Beatles at the beginning. So John, is this your final letter to the world?
Well, it is. I mean, for a will to be recognized in British Columbia, it should be a written document signed by the person who made the will. They're called the testator, or we now call them the will maker, with two people who have to be present at the same time who both have seen the person sign and they've seen each other sign. And so it meant that if someone did their own will and they had their neighbors witness their signature and then they went across the street and got their other neighbor to witness their signature, that would not be valid.
So they all have to be in the room.
They all have to be present. And there's a lot of other issues which we weren't going to focus on today, but the person who's signing is supposed to be competent and doing it freely and voluntarily without fear of intimidation. So if they're being forced to do it by their daughter to disinherit the son, and the person was under the control of the daughter, that could be challenged. But the law on principle is pretty simple. But of course, what's in the will is a totally different situation. But
now, how legal is a will that has not been looked at by a lawyer or a notary or somebody that has some background in this? If you just write on a piece of paper, these are my wishes, and you have enough people witness it, is that legal?
Sure.
It is?
Well, except for it's changed too, though, because they brought a new law called WESA, Wills, Estate, Succession, and Administration Act, as of the...
is this provincial or federal?
Provincial law, March 30th, and they've recognized something called a testamentary document, which John can talk a bit more too about. And we did talk earlier in a previous show about it, because you could have a whole show about it. But for the first time, if there's a document that's in writing by the person, it could be recognized as a document which may form similar to a will. And there's been a few cases on it, and sure, John, want to comment on that further?
Yeah, just to emphasize the answer to your last question, though, you don't need, strictly speaking, a lawyer or a notary to review a will for the will to be valid, as long as it meets all the tests for validity under what is now the Wills, Estates, and Succession Act, what we used to call the Wills Act. The Wills Act covered this area. It's got to be in writing. It's got to be witnessed, as John described, in the manner that he described. There's no lawyer in that.
But your best advice is to have somebody professionally look at it.
Well,
right?
I mean, it's just like you can fix your own car or build your own house, or you can operate on your own leg. But are you going to do it well?
Yeah.
That's the question.
And you see, because we get a lot of American television in Canada, you see these will kits that are advertised in the United States. So your advice to people who see these?
Yeah. Well, I mean, it's great business development for us, especially in estate litigation, because those will kits are pretty basic on one level, but they're certainly not tailored to people's circumstances. In many situations where the will really should be tailored to people's circumstances because of the way that people's families are structured or their estate or their assets are structured. But yeah, I mean, those wills kits, at least the ones that I've seen, do make provision for a signature from the will maker and for witnesses. And that's a big part of the formal validity of a will. But really, it's what we do goes beyond formal validity. That's the easy part. Whether it's an appropriate will, a proper will, a will that will withstand a challenge from a disappointed beneficiary, that's something else.
Quick question here, because I know a lot of people may be thinking, well, this sounds, we've got two very experienced lawyers here, and what does it cost to do a will? Because I think a lot of people are scared away, and they think I can do it the inexpensive route, going to a package. What is it?
I don't want to put. I mean, I'd say generally for a husband wife, it's usually under $1,000. I mean, sometimes there's other things that have to be done at the same time a will does, such as a power of attorney, or maybe something called a representation agreement, which is healthcare decisions. And then
insurance and things like that.
Yeah,
right?
but and maybe, in the process, sometimes checking land titles to see whether there's a mistake, how the house is registered, things like that. It's like when you have a will done, it's like doing a legal checkup, because people don't see lawyers very often. And I'll have clients of mine that think John and I are their lawyers. We haven't seen them for 15 years because they haven't needed us. But when you've got, $1 million estate, if you don't do it properly and it goes to litigation, the cost of doing a proper will and or power of attorney is probably equivalent to 3 hours of litigation time. And litigation could cost thousands of dollars. So
it's money well spent.
It is. And if you want to, you either do it properly or else you go home. I mean, a lot of people doing these kits, even the BC basic kits, maybe 70% of them do it properly, but the other 30% don't, and it just creates, and of course they're gone, but it creates a problem for the people who have to deal with it, and there may be an issue that it's not done properly, so the court has to interpret what these people mean. So it's so
as lawyers, your best advice is to get proper counsel to go through this, because as you're absolutely right. I mean, it's headline news every month when the real estate numbers come out and everybody's richer on paper, and boy, that's everybody comes clawing for it when someone passes away, so better get it set up right.
Well, the other thing, when they brought in WESA last 2 years ago now, it's created a certain degree of uncertainty because it drastically changed a lot of the rules, too.
We'll get into that in just a moment. I just want to let everybody know we're listening to The Law Show on CL 650 in studio. John Lakes, John White, partners at LakesWhyteLLP, over 25 years experience in North Vancouver. We'll talk more about what you should be looking for with the different people who are signed on to look after your estate once you're gone. Next on The Law Show.
There's more of the show still ahead. This is The Law Show on CL 650.